What do you say?
Well, let me say good morning to you and then my co-panelists and the cherished viewers across the globe. Council, we accept the decision of the Supreme Court. We are a law-abiding political party, but we disagree with the ruling. We disagree with the ruling totally. Totally disagree. And we are waiting for the reasoning behind of their ruling on the 6th of February. They indicated it to come out on the 6th of February. Then we'll advise ourselves appropriately. Because if you look at, let's set the business straightforward. The Supreme Court doesn't have jurisdiction over the substance of the matter. If you look at the Enabling Act, the PNDC law 284, that talks of election petition. Under Article 99(1) of the Constitution, it is only the High Court that goes into election petition matter. Supreme Court doesn't deal with that.
Supreme Court is a supervisor of the realm.
But it doesn't go into
if something goes to the High Court or any other court, the Supreme Court has power to review it.
We agreed. But we are saying that when it comes to the substance of the matter, going to the nitty-gritty of election petition, under Article 99(1), it is the High Court. That one there is I defer that one to you. Now, when you look at the matter critically, what the Supreme Court did was based on technical issue of gazette, not the substance in itself. If you go and look at the ruling of the High Court, page 151, it's very clear that the election was properly rigged. The judge makes references to those things. And I have the ruling, I can make it available for you, for them to tease out that portion where the judge, the learned judge, mention of a polling station recording 1,422 votes. Council, you know that we don't have a polling station like that in Ghana. That has a voter population of 1,000. The highest we have is 750. 750. If you have more than 750, it will split into two. But this is a kind of voting that occurred in Kpandai constituency. Now, why are we battling the issue with Gazette? And that is
so. For the Gazette, you mentioned the matter of, is it overvoting?
That is what is pointing at.
Okay, that there is a polling station. Which has less than 1,000, but there was recorded over 1,000 votes.
1,000, yes.
That's what do you make of what Dr. Tanko-Computer says? In that case, hold that the elections have been, damaged in this particular place. So go and correct it, rather than say go and do a whole new election.
That was not the only one. Don't forget, Honorable Nyindam won about 3,000 votes. In two polling stations, another polling station reported 1,200 votes. So that means in two polling stations, you have scored almost 2,000 votes. So what are you talking about?
So impeach those two.
So we are saying that is why the judge was looking at it. And we said that when we sent our reliefs to the High Court, we sent 14 reliefs. And then at the case management, this 14 was consolidated, set out for trial. 3 issues were set down for trial. And one of them was we were asking for the nullification of the entire results because of the infraction of Regulation 37 and 39 of CI 127 by the electoral officer and the presiding officer, the returning officer of the constituency. We gave copious evidence and tendered evidence to show that they violated these enabling 2 regulations of the CI 127. And we convinced the judge to believe that, yes, they didn't do it the right way. They violated those 2 regulations. And those 2 regulations borders on the collation of results of parliamentary election. And it was very clear about it. And so we did all this cross-examination with them in order to, the ruling came out on 24th November. And it was very clear. I am not surprised my colleagues' opponents ran to the Supreme Court because they know if they had gone through the process of appeal, going to appeal court, they were going to suffer another defeat over there. Because I don't know what kind of new evidence they were going to adduce based on what we had cross-examined them in the electoral officer. So they decided to go on this tangent, of which we are saying we will go into it. And when we file our affidavit in opposition to their application at the Supreme Court, we're citing them for fraud, the 2 of them. And I'll give you the elements of fraud that we are going to pursue on that.
In your main petition in the Tamale High Court, you were clear about a particular number of polling stations that have been affected, correct?
I said we have set out 14 rules.
I understand
and one
that.
of the lists was what we are talking
I understand that.
about the number of polling stations.
How many of them?
We had set out about 51 of them.
41.
No, 41 of them, the polling stations,
Right.
indicating that they should look at these 41 because we're making reference to the regulation 37 and 39 of the
So the
population.
judge was faulted by many members of the public, including some lawyers, that what was before you was to determine 41 polling stations where the voting was allegedly rigged.
Council, that was
So why do you come to a conclusion by saying that let's go have a rerun, I've annulled the whole thing, go have a rerun in the whole constituency?
Council, at case management, these 14 reliefs, when we consolidated it into the 3 issues set down for trial, one of the reliefs among the 3 was the nullification of the entire results of the 152 based on the infractions therein. So it wasn't that we're asking the judge to look at only the 41, but we're asking for the judge, which is the 3rd issues set down for trial. The last one, in fact, I wanted to read that one, the 3 issues for trial.
All right.
And the last one was...
You're going to the merits already.
Yes, and that's why we're saying. So it wasn't only that we were going in for only the 41, but we were also asking the judge to nullify the entire thing because it violating regulation 37 and 39 of CI 127.
You're right, there was a relief like that.
On that.
Now let me go to Dr. Arthur Kennedy. Just,